happy to welcome you to this event in our speaker series featuring Louise Arbour, President and Chief Executive Officer of the International Crisis Group. Louise, of course, is a well-known and cherished figure in this community, as today's overwhelming attendance attests to. You have her full biography in your papers, but let me just point out some highlights and how they illustrate the special place in this place that she occupies and why we at IPI leapt at the opportunity to present her today during her visit to New York. In 1996, the UN Security Council appointed her as Chief Prosecutor of the International Criminal Tribunals for the former Yugoslavia and for Rwanda. After 3 years in that position, she resigned to become a justice on Canada's Supreme Court. And in 2004, she became the UN High Commissioner for Human Rights. She assumed her current position heading up the International Crisis Group in 2009. Her subject today is What the Rule of Law Really Has to Offer, a title that she suggested after we said we would love to have her talk about the rule of law, since it is the focus of the upcoming session of the General Assembly and because of her eminent qualifications to address the subject. As you know, I'm sorry, is this not working? Have you been hearing me or not? As you know, the Assembly will have a high-level meeting on, quote, the rule of law at the national and international levels on Monday, September 24th, the day before the opening of its 67th session. The General Assembly has stipulated that the meeting will result in a concise outcome document, and the Secretary General has proposed that the Assembly adopt a plan of action for the rule of law, agree to a process to develop clear rule of law goals, and adopt other mechanisms to enhance dialogue on it. IPI has scheduled some public meetings in the coming weeks and months to promote that dialogue, and there is no one better to kick it off than our guest today. So Louise, a warm welcome back to IPI, and the floor is yours.
Thank you very much, Warren, and thank you very much, all of you, for being here. I hope we can have a conversation about the rule of law. I should say at the outset that the reason I'm now keen to talk about this topic is I think I've had a kind of epiphany. Ever since I joined International Crisis Group as the President and Chief Executive Officer, I've had a bit of a personality crisis. In my previous life, I was, for the most part, in the legal profession, even though I sort of drifted bit by bit. And now, of course, in International Crisis Group, as I'm sure most of you know, our organization, we work on conflict prevention. So there's still a legal component, and I will suggest to you rule of law is a big one, but it's not the centerpiece. But when I travel recently, for instance, when I arrived in Kinshasa or in Amman, when I fill out the customs and immigration forms, it says occupation. I have to admit, president seems a bit presumptuous. It could be misunderstood. So usually I hesitate, and then by default, I write lawyer, which makes me realize that I think at heart, I've always been a lawyer. So I'm reclaiming this title today in talking to you about the rule of law, and I will start for the lawyers in the room and the few friends they have on earth with a cri de coeur. Lawyers of the world, unite. Right. I am concerned, and I'm going to try to flesh out a few ideas, that the rule of law, in my opinion, is the centerpiece of the enterprise in which the legal profession is engaged. And I am a little bit concerned that we're selling it on the cheap. That we have not embraced the complexity and, more importantly, the fundamental promise that the rule of law really has to offer, both in the field of development and in the field of security. And I'll try to flesh that out a little bit. I am very concerned that we're going to buy into the trappings of some of the easy features of the rule of law, and we're going to miss its core element. The reason why I think this is of concern is because then we won't have any other word to call what I consider to be the substantive part of the rule of law. So I don't think there's anything wrong, frankly, in assisting countries to develop proper security systems, law enforcement mechanisms, courts, police forces, and so on. But we shouldn't call that the rule of law, because when we get to what the rule of law is really all about, we will have already voided it of most of its content. So I will talk about this issue in two general terms, and then I'll try not to speak for too long, because I'd be much more interested in an interactive conversation. I'm sure some of you will have a lot to say, including possibly challenging what I will put before you. In my understanding of the rule of law, I won't go through the history or through any kind of legal theory, but fundamentally, in my opinion, what the rule of law means is that it embraces the principle of equality before the law. That is, equality before and under the law, equal protection and equal benefit of the law. That is the rule of law. Police and prisons and judges are institutional features that are set to move this agenda forward. But essentially, the rule of law is the vindication of substantive protection by law to override otherwise human arbitrariness. One of its best known features, and I will put it to you, the one on which so far we're not doing that well, is the principle that no one is above the law. It's a pretty fundamental, I think, feature of the rule of law. Again, not the only one. The most important one is not just equality before the law, no one is above the law, but an entitlement to equal protection and equal benefit of the law. And the reason I think this is very important is because it talks about just laws, not just laws justly enforced. Not any law, in my opinion, qualify to be under the umbrella of what we call the rule of law. And I'll give you, I think, a pretty startling and, if not outrageous, example of that in a few minutes. So what I first would like to raise you is two parts. First part, is there such a thing as international rule of law? I understand around the UN, there seems to be an acceptance that there is such a thing. It's very puzzling to me. I'm not sure that one can seriously talk about an international rule of law. We can talk about international rule by law to some extent, but I think we're a very long way from the kind of equality before and under the law that I say is at the heart of what this concept is all about. Put another way, I don't think we're quite at the eve of the legalization of politics on the international scene. Those who will want to promote international rule of law will talk to you about treaty ratification, which is a very good thing in and of itself. But to me, it's rule by law. So more legal frameworks to govern activities. And as I said, there's nothing wrong with it. Actually, it's pretty good. It's even better when it's enforced, but that's another chapter. In the field of international human rights, for instance, the legal treaty-based infrastructure is admirable. Its enforcement is mediocre, and its institutions for enforcement are conceptually very deficient. You cannot have, and I won't go into the details of that, but in the international human rights framework, you cannot have duty bearers, i.e. states, be the protectors of rights holders. You need a neutral arbiter, that's usually called a court, and I'm not holding my breath that in my lifetime we will see an international human rights court. So for that chapter, no one is above the law. I think we sort of started to embrace this concept with the creation of international criminal law. With the creation first of the two ad hoc tribunals and eventually of the International Criminal Court. This was probably one of the most daring, bold step taken by the international community to advance the idea that no one is above the law. And in that sense, part of a kind of international rule of law concept. We've done great, as we usually do, on constructing institutions, because building institutions is like building roads. It's what donors can measure. It has something concrete about it. It's very tangible. We're not that good at actually infusing content, let alone a genuine culture, into these institutions. If we start back just on international criminal law and look at where we are advancing this ideal, this principle that no one is above the law, in Bosnia, in the former Yugoslavia generally, after now more than 15 years, nearly 20 years, I think we've done as well as could have been expected, particularly for a first experimental effort. You will say at tremendous financial cost. That's true, but again, everything is relative compared to, say, peacekeeping operations, not all that dramatic. We've done very well at creating an environment where the international community basically had the monopoly, had primacy over national court. This was a truly no one is above the law international initiative. And as a result of that, warlords were disenfranchised, which we miserably failed to do in the case of Afghanistan, for instance, equally so in the case of the Democratic Republic of Congo, as the mapping report that was done under the authority of the High Commissioner for Human Rights amply demonstrates. So we started with, I think, a tremendous investment in the idea that no one is above the law. Unfortunately, with only the ad hoc tribunals, Yugoslavia, Rwanda, the central question of the lack of universality was, in a sense, was a defeat for the principle that no one is above the law. Certainly when I was the prosecutor for ICTY and went to Belgrade, I was asked repeatedly, why us? Why did you one day decide you're going to start and pick on us? Where were you? In those days, they would say, in the killing fields of Cambodia and in all the abuses in the dictatorships in Latin America. Why us? And it took me a long time to find the rule of law correct answer to that question. I think there's only one, and it's as follows. The fact that others, equally guilty, are not brought to account doesn't make you less guilty. However, it makes it less just to single you out. And therefore, we should not let you go, but we should all work together towards making sure that no one is left out. Hence, the International Criminal Court, based on the principle of universality. Now, where are we now, almost 20 years after the creation of these ad hoc tribunals, with this fundamental international rule of law ideal that no one is above the law? Well, we've just had the conviction of Charles Taylor, highly celebrated first head of state convicted under an international system. However, his conviction was before a specialized court, not the ICC. So this was, again, under these exceptional regimes. Where are we more broadly? Ben Ali walked away, although I understand that Tunisian authorities have a tremendous interest in trying to initiate some accountability mechanism. Mubarak is on trial in his own country. Gaddafi was executed. And President Bashar, radio silence. No Security Council initiative, no mass movement for accountability. And why is that? It may just be that we are spooked, that there is a sense now that the perennial tensions between peace and justice have been left so unresolved that to activate it in this case is too risky for risk jeopardizing a, let me say, otherwise almost non-existent peace process. But still, with the faint hope of a peaceful resolution, it seems that we're all frozen. This brings me to no one is above the law, equal protection and equal benefit of the law, and the role of Security Council referrals before the ICC. It has one thing going for it, I think, Security Council referrals, which is it expands the reach of accountability. In my view, though, it does so at a price that is inconsistent with the principles of the rule of law, because it's not, the driving force is not legally based, it is politically based, and it taints the entire enterprise. And we could, if we had time, engage in a comparison of the Security Council referral process in the case of Darfur, particularly with respect to President Bashir, and in the case of Libya. Look at the time frame, the kinds of responses, and where we are left in both cases. Security Council inertia, in one case, an indicted war criminal who's still in power and has been so since he was indicted in 2009 in Sudan. And on the other hand, 2 remaining indictees in the case of Libya that it seems the Libyans themselves no longer want to see referred to the ICC. In the end, hardly a vindication of equal protection and equal benefit of the law. And just to complete the chaotic picture in which we are left now on the principle that no one is above the law with respect to probably the most serious issues. In Yemen, President Saleh negotiated some amnesty for himself and his entourage, which was immediately denounced by the population, but everything fizzled out. In Bahrain, a commission of inquiry, led by Sheriff Bassiouni, was appointed. The authorities seemed at the beginning to be willing to be responsive, and yet nothing happened. I will not say much about the Gaza Goldstone report, but I will say something about Sri Lanka, about which International Crisis Group has reported repeatedly, where between January and May 2009, by UN accounts now, some 40,000 civilians were slaughtered on the beaches of Sri Lanka, and we have been unable to mobilize, until recently, the modest mobilization of the Human Rights Council to keep the cry for accountability alive, a timid, very timid voice of accountability. So we're very good at building institutions. We're very bad at transforming cultures when it comes to these fundamental premises of rule of law. Let me say a few things about rule of law domestically. I think it will feature very prominently on the development agenda. I think many donor countries will be very attracted. It's the new mantra, after governance, democracy, now rule of law. And I'm very concerned that we're going to fall again on the trappings of mistaking institutions for substance, mistaking form for substance. Enormous amounts of money will go into the institutional trappings of the rule of law, which in fact is heard by many authorities as law enforcement, which particularly authoritarian regimes are very fond of. Robust law enforcement, a good thing for most of them. So trained police, more courts, and with any luck, good ones, but that's not always seems to be a requirement, particularly since to build good, competent, credible judicial systems, you need decades, not 6 weeks training of judges by foreign judges who come from different legal systems, including Western systems that are barely affordable for Western countries and therefore not exactly easily exportable. So we're going to go through and then prisons, of course, the ultimate rule of law institution. And I should point out, just as a little parenthèse, opening brackets, that many years ago in Canada, I conducted an inquiry into the prison for women, as it was then called, P4W, as it was then called. And it was a revelation for me on the rule of law issue. Prisons are the environments where regulations, i.e. laws, are the most present. Everything is regulated, what you wear, where you sit, what you eat, who you talk to. And yet the rule of law is profoundly absent. There is no culture of respect for rights, of laws are there to be complied with only if you have to, preferably avoided if you could find a convenient way to go around them. So the danger, I think, is the building of so-called rule of law institutions that are merely law enforcement institutions. Why is it not good to simply enforce laws? It's very good to enforce just laws. It's very bad to enforce unjust laws. And to distinguish between, and that brings us to the fact that the rule of law has content. It has substantive content. It's not just the formality of being ruled by law as opposed to by human arbitrariness or discretion. I think the best example of the perversion of the rule of law by emphasizing only its formal model came from the former Chief Justice of the Israeli Supreme Court, Chief Justice Barak, who in his book called The Judge in a Democracy gave the example of the treatment of Jewish criminals, prisoners, who were incarcerated in Germany at the time the Nazi regime came into force, and it caused a dilemma for a regime that was very committed to law enforcement. What do you do with those who are in prisons? And so the solution that was said to be in conformity with the rule of law is you let them finish their sentence, then you take them and you execute them. And this way, it was perceived that the rule of law had been fully respected and vindicated. And a more recent example, you may recall in the last decade, there's been a lot of talk about torture and the absolute prohibition of torture, which is a rule of international law expressed in the Convention Against Torture, one of the very widely ratified international instruments. And they were voices claiming that since torture was not completely eradicated, even though it's absolutely prohibited, it would be more consistent with the rule of law to issue torture warrants. So you would go to a judge and ask for permission to do a few enhanced interrogation techniques that probably amounted to torture. This way, torture would be under the rule of law rather than be left to potential abuse and arbitrariness. To me, this is a profound perversion of the rule of law, to void it of its content. So I believe that if the UN is going to be seriously engaged in the promotion and the enforcement of rule of law principles, doctrine, values, it cannot shy away from the content of laws. And when it does so domestically through a development agenda or any other form of peace and security assistance, it cannot only promote the building of institutions and a formal rule of law regime. Not only to do so is a betrayal, I think, of everything the rule of law has to offer, but I think it's worse. It can play right into the hands of authoritarian regimes who have no commitment to the substantive protection that the law offers. To incorporate that, you need to incorporate most of the fundamental human rights entitlements, civil and political rights, economic and social rights, and more fundamentally, the principle of equality before and under the law. Thank you very much.
Thank you, Louise. I just want to comment on your shout out to lawyers. I feel a particular kinship with lawyers because as a longtime member of the mainstream media, I occupied the same position they did, which was to be a member of the most reviled profession in America. Of course, neither lawyers nor journalists are in that situation anymore, and for that we owe enormous amounts of gratitude to bankers. I would love to take questions and comments. I know Louise is eager to have a conversation, not just to make a speech, so if you would raise your hand, I will call on you. The ambassador in the fourth row there. If you would please, if I could ask you to stand. We are webcasting this, and you need to hold the microphone very steady when you speak. Please introduce yourself. I know who you are, but the audience doesn't.
Well, my name is Kazuo Kodama. I'm the DPR of Japan to the UN. Well, thank you very much, Ms. Arbour, for your very thought-provoking. I think it's a very intellectually challenging, presentation for all of us. I can be very brief. I want to ask you, while listening to your, of course, expose, you continue to emphasize that let's not lose sight of forest. Maybe, simply mistaking, the trees for forestry in the sense that if we continue to emphasize the importance of institutional building, law enforcement capacity building, and the judiciary setup and all these things, we should never ever forget the contents, right? And you say, yes, I think it's correct to say, let us not forget about the importance of rule of, equality of law and equality of protection, I think, under the law and so on. However, what I really want to ask you is that, but that's, you said very well. But again, we are back to square one. I mean, for example, in the case of Somalia, or even in the case of Afghanistan, how you translate what you just preached to us on these fundamental importance, I think, into a more, say, action-oriented, I think, prescription for us, say, police, the practitioners on the ground, be they in UN Security Council or in the General Assembly, or in Afghanistan or Somalia. I also, you didn't mention a word about the corruption. And here again, I think this, really, I think that is also very important. Again, I think we have to somehow send a more positive message to all those people on the ground who are struggling to turn around the situation. To those people, I don't think it is simply enough to justice must be done. We have to come back to wrongdoing being perpetrated by the leaders. We have to come back to them. Justice must be done. I think that is, I agree, maybe in the case of, Sri Lanka or another place, it's perfectly okay, but I think we need to maintain balance. And I think we have to, when we promote the virtue of rule of law, I think we have to also take care of the very needs of the people on the ground, I think, to encourage them. After all, they have to build their nation. They have to build their statecraft to protect their rights, right? So this is my question. Thank you.
All right, well, you're asking me to translate a doctrine into its working parts, but before I do that, I want to put another spin on the doctrine itself. And I will suggest to you, I did not invent that. I think great legal thinkers have made that comment way before I did, that the purpose of law in a free and democratic society is to liberate, not to restrain. When we build security environments, we should never lose sight of the ultimate purpose of a security environment. It is ultimately to liberate people, not to restrain them. The restraints on some come for the benefit of the liberation of the greater number. That's one agenda. And as long as we have security initiatives that keep very well focused on the ultimate objective of a security environment being to liberate, not to restrain, I think a lot of things follow from that. A lot of concrete things follow from that. The second one is that law, and that's where law enforcement can be so deceptive, particularly the security sector, policing and so on can be so deceptive. Law works by compliance, not by coercion. Just laws are not totally self-enforced, but they are, for the most part, self-enforced. I was a judge for many years in Canada. I was always persuaded that the only way the system works is not because there are hordes of police officers outside to take people into custody. It's because, as a judge, when I put on my gown and I walked into a courtroom, I walked in and people rose. The day they stop rising, the system has stopped working. I can't go one by one and pull them up. I can't call the police to go to the courtroom and make people rise to the court. You rise as a sign of respect. And as an add-on, in Canada, the judge bows and the people bow. But that's it's a side issue. It's a sign of mutual respect. So I think we need to work, again, it's very difficult for me to try to unpack that into programs and activities for DPKO or for donor countries. But if we keep very focused on the idea that we need to build a culture of compliance, you do that by building just laws, and in particular, by having laws that extend full protection to minorities. Minorities fare very badly in purely electoral democracies, even in the electoral systems that are free and fair, and God knows those are few and far between in a lot of recent examples, the DRC being the most scandalous one. But even if we manage to promote free and fair elections, we do very little for the protection of minorities, whether it's ethnic, linguistic, religious minorities, whether it's women or others who are not minorities but are treated as such. So I think these are the kinds of legal frameworks that we need to promote.
In the back of the room, Shamina, if you could stand, please. Thank you.
Shamina de Gonzaga, World Council of Peoples for the UN. My question is what thoughts you have about how the very useful breakdown and clarifications you've offered today could be popularized in all societies. I think the discussions around the use of waterboarding and so on illustrate that there's hardly a consensus at the societal level as to what is acceptable and what's not. And I feel like there might be a missing link in terms of how respect for the rule of law could be translated into a more the level of all people.
Well, I think first, it should not be, or stereotypes, unhelpful stereotypes about the rule of law should not be perpetuated and promulgated, in particular by the United Nations, reducing it, having a very reductivist, whatever. Reducing position, again, encouraging a perception that the rule of law is about law enforcement. I think we would already go a long distance. I know it's difficult because it seems very abstract, but if we make the effort to give concrete examples that have a lot of dramatic impact, that could be done by those who know. So again, lawyers, judges, and journalists, if we can have a public conversation about what the protection of the law really means, that it's not about just empowering states, whether they are democratic or not, in getting better at repression. It's the same thing with capacity building. Before we build capacity, we should have a very sober diagnosis about what is the deficiency. If the deficiency is a deficiency of political will, and you build logistical capacity for law enforcement, this is very bad. That means you're developing the skills of a regime that has no real political will to create this kind of system of equal protection and equal benefit of the law. So to me, to build the capacity when the deficit is not a genuine technical capacity deficit, but a deficit of political will is worse than doing nothing.
Ambassador Schapper.
Thank you, and thank you, Louise. Sorry, I'm Herman Schaper from the Netherlands. Thank you for your very challenging and interesting introduction. I'm not a lawyer myself, but as I understand, there's an old saying already going back to the Romans, summum jus, summa injustia, in the sense that you could have something which is completely 100% according to the law and 100% unjust. So isn't that tension you describe, isn't that there always? In a sense, one shouldn't be too surprised that it manifests itself. And then it leads me to the question, is it now worse in the field of international law and international rule of law that you gave a very passionate critique? Is it because something is really going completely in the wrong direction, or is it that you're simply concerned about something which is perhaps inevitable, but we need to be careful that it doesn't get out of hand? Something. How bad is it really? And then and then secondly, I mean, if we should have more focus on the content and not just on the execution of the law, how do we organize that within the UN? Is it what is the best, and internationally, I think, how do we ensure better that the laws, as far as the content is concerned, are the right, just kind of laws?
Well, I would like to give you a very radical answer, but I think I have to give you a very balanced one. I think on your first question, the most we could do is to minimize the we cannot control, obviously, the content of all laws in all countries. There's sovereignty issues, and there are a lot of options. Within the range, a lot of options are consistent with the aspirations of that particular people and a lot of them are not acceptable. Discriminatory laws, laws that either directly in intent or in effect discriminate on the basis of race or gender or religious affiliation and so on, should not be, we should not support a machinery of enforcement of grossly unjust laws. How we exercise that judgment, I think, we have a lot of guidance, again, from international instruments, human rights instruments, environmental instruments. We have a whole range of options, but there's no purity. There's not just one legal model that has to be adopted by everybody, but we should stop shying away from content. I think that's my message. We should stop believing that if we build an anti-corruption commission or a human rights commission in a country, we've made a great achievement. We've done nothing unless there is a culture and a political will and a monitoring for content. So I think in the same way in all laws, to develop more policing capacity, more law enforcement capacity, may just be feeding into tremendous tools of repression if we don't, at the same time, expose deficiencies in the content of the laws that we're seeking to enforce. And we should be prepared to do that very frankly.
Jeffrey Laurenti.
Jeff Laurenti with the Century Foundation. First, the image that you had offered of the rule of law being evidenced in the fact that your courtroom rises in respect to the entering judge in her robes leads me to ask you, this is more of an aside question to the real one, looking at the most current case in Guantanamo over the weekend of defendants who aren't going to rise. Now, maybe it's a military commission issue, but it would probably be the same in a federal district court if we're here in Manhattan. Just if you could give your suggestions about dealing with cases where people reject entirely the whole system of law as it is understood in certain cultural contexts. But I do want to take issue a bit with your bifurcation between institutions where we've been great at building them and the lack of a development of a corresponding culture within each society. Think back in the American South 40 years ago, we were told you don't want to have civil rights laws that are coercive because it has to come from within. People have to already accept. Don't those institutions themselves, by their creation, by their creaky application, begin to create the conditions for a change in culture? And absent those institutions and the reinforcement of them, how would one achieve a change in culture? It's very easy, actually, to backslide, even when you have had such a culture, as we've seen in our own country, that is, Americans have seen in their own country over the past dozen years. Shouldn't we see the establishment of institutions piercing that veil of inadmissibility of interference in internal affairs as a giant step forward already?
Well, on your first question, I don't want to suggest that if one person doesn't rise, a country's national system will collapse. For the most part, though, when the system operates as it should, that is, as it is perceived to operate, certainly where I come from, most criminal defendants rise. They would rather not be there, let's be very clear. It's not their first choice. But for the most part, they will rise. And, they will ultimately accept the verdict of the court. Some won't, and in fact, I think that the minute there's a taint of sort of political undertone, the defiance, challenging the system is a very nice strategy for avoiding having to deal with the substance of the charges. But I think it is problematic in the US that in military courts, you see this kind of guerrilla warfare in the courtroom. It's symptomatic of a rejection of the system itself, and it's easier to do it in a system of exception in military courts than it is in the regular courts, and it will attract, I think, slightly more support, very marginal. I can't see the American people rising in protest on the use of military courts. But exceptional systems are at risk, I think, of triggering exactly that kind of very contemptuous rejection. as long as it remains confined, it doesn't threaten the entire system, but it's always, I think, a somewhat risky enterprise. And of course, I think you're right that institutions, particularly institutions that over time develop their own courts, for instance, their own competence, integrity, respect, professionalism, independence. Brown and Board of Education had to happen in court in a coercive fashion. Not everything happens just by happy compliance and cultural enlightenment. So there are moments where coercion is necessary. I mean, the laws of homicide, murder laws domestically could not be abolished, even though, for the most part, people don't kill each other, not because there's a murder statute. But at the margins, you need this kind of coercive element of the law. And I think the building of institutions matter. But if you build institutions that have no other capacity or mission than to be the tools of further repression, then I think it's completely self-defeating.
I'm going to take actually 3 questions, Louise, if you don't mind, in the interest of time. Bill Pace in the back, gentleman here, and then Ann Phillips.
Bill Pace, and I'm General Secretary of an old peace movement that actually is a rule of law, a peace movement based upon the rule of law as opposed to the rule by law. The question I wanted to ask was, I thought your description of your situation in the former Yugoslavia, why us, and your response to it. But I'm not sure then where you were going with the situation that the International Criminal Court faces with the referrals from the Security Council, because should those who believe in the Rome Statute and the ICC not favor any referrals because the Council is for the foreseeable future always going to be very selective and not even enforce its own referrals once they do make referrals? I'm curious if you could go a little bit further in your description of the problem that you're seeing arising from the referrals in the ICC. Thank you.
Just hold that a second.
Hi, Andras Vamos-Goldman. I'm the Executive Director of Justice Rapid Response. My question really is a follow-up to a couple of questions. I'm sorry for pressing on with this, but what is your advice to us who are lawyers, who are practitioners in the international criminal justice field, who are trying to move things along with the tools that we have, with the institutions that exist, with the laws that have been passed, with as imperfect as they are? How do we help get from where we are to where you want to get us to?
And finally,
Yes, my name is Ann Phillips. I'm on the board of IPI. Perhaps what I have to say is a bit redundant, but I would like to add to what Jeffrey had said, Jeffrey Laurenti from the Century Foundation. I think what he said is very, very significant. I mean, if you think that that very recently the concept of sovereignty superseded everything, and then Kofi Annan introduced the humanitarian intervention, there was great outrage because this was interfering with sovereignty. Then the right to the R2P, the right to protect, or the whatever. You know what I'm talking about.
Responsibility to protect, yeah.
Was also considered a breach of sovereignty and now is really accepted. And the concept of an international criminal court is really quite an immense step forward in changing culture, international culture. So maybe we're being a little bit too impatient in terms of the concept of changing culture. I think we've made very, very big steps forward. And thank you, by the way. It was a wonderful presentation.
3 questions. Any order you'd like to ask?
Okay, well, I can start with this one. I don't disagree for a minute, but I can't afford to be patient in perpetuity. So we have made tremendous progress. I don't want for a second, to have, what do we have now, Bill? 120 members of the ICC? I mean, this is, when you think that when the 2 ad hoc tribunals were created in 93, 94, this was already a stunning development, 50 years after Nuremberg, after absolutely no mechanism of international accountability for these atrocious crimes, we have made tremendous progress. The key now, though, is not to keep our eyes on the proper horizon, not to get caught up in institutional developments and budgets and a building and having another courtroom and forgetting what is the fundamental mission. I think, so I don't deny for a minute that we have made progress. What I want to emphasize is the kind of do no harm, not to get stuck in the formal institutional side, which could do harm. I'll come back to what Bill Pace asked about my problems with Security Council referrals. As I said, the only virtue that I see they have is an expansion of the reach of accountability. So with the Security Council referral, you could go into countries in which you would have no access because either the nationals are not of a country that has ratified or the crime did not take place on the territory of a ratifying party. I understand that. And that is, it has a lot going for it. To me, the price is too high to pay. This is, again, a very good example of a kind of an abandonment of the content of rule of law. To have a Security Council referrals, you have to have the acquiescence, if not the enthusiastic initiative, of at least 3 countries that continue to shelter themselves from the scrutiny of the court. How is that consistent with the principles that no one is above the law and equality before and under the law? To have the trigger mechanism, it's as if though in a domestic system, judges, prosecutors, and police were above the law, but they would prosecute everybody else. Even if they did a very good professional job at it, wouldn't it be at the core very problematic to have a trigger mechanism that is not consistent with universality, which is at the heart of the Rome Statute? Its aspirations, its mission, the Rome Statute, is universality. That should be consistently promoted with tremendous vigor, rather than say, well, look, it's not bad, because we could catch a few others on the margins by a Security Council referral. So, and frankly, the way it's been applied in practice, in my opinion, completely vindicates my skepticism vis-a-vis its utility. But that's another issue. And yeah, I think, again, it's the same thing. It's kind of do no harm. Don't get into the trappings of rule of law, because rule of law is a very dangerous tool if you reduce it to its institutional or formal mechanisms. As long as we use it in that kind of eyes wide open, do no harm, speak about content, keep your eyes on the substance, we are making progress.
In the back of the room, thank you. Actually, and after that, Paul Mikoff, right next to you. We'll take 2 questions at once.
Thank you. Anthony Simpson from the New Zealand Permanent Mission. First of all, thank you very much for a fascinating presentation today. I have 2 questions for you, both of which relate to the question of equality before the law in the international setting, and both of which are carefully designed to get you in as much trouble as possible. The first one relates to perceptions that I know have become a bit more widespread in some parts of the world regarding the question of selective use of the international rule of law. In other words, suggestions that the international rule of law is applied much more vigorously in some regions and against some types of countries than it is against others. And obviously this is tied up with the question of Security Council referral, but clearly not exclusively. And I'm thinking in particular here of some of the concerns about ICC indictments in Africa. The second question I have relates to the interplay between political considerations in pursuing the international rule of law and purely questions of ending impunity. Obviously, one of the motives that might lead people to pursue an indictment of some kind internationally would be to try and put pressure on a particular party or a particular individual who's involved in particular acts that may be considered particularly egregious. And in that way, it's very much a utilitarian tool to try and end a conflict or put pressure on one side. Obviously, there is a flip side to that too, where in some cases there may be a perception that use of indictments may actually become a barrier towards resolving peace or stabilizing a particular situation. How do you think we should best reconcile those tensions where the political aspects of as I think you said, potentially tainting the international rule of law, are actually driven by, some would sort of say, quite humanitarian considerations in terms of using them to try and prevent atrocities or to end a conflict. Thank you.
Thank you. Paul Mikov from World Vision. Ms. Armour, thanks for this stimulating discussion here. You beautifully stated that the purpose of law ultimately is to liberate and not to restrain. Obviously, this is a positive, very constructive understanding and disposition to law. And I wonder if you could reflect a little bit on what import, this kind of understanding, import and disposition to law might have in situations of perennial dilemmas between and tensions between peace on the one hand and justice on the other. Thank you.
I think the two questions, in a sense, are interrelated, particularly the second part of the first question about whether the use of indictments can be an impediment to peace. First, I'll answer the very first question, because I think that's very different. The question of whether the ICC, having had numerous indictments in Africa, is seen as either double standards or selective enforcement of the law. I don't think so. I don't have any problems with that, contrary to the problems I have with Security Council referrals, because these are all countries that have ratified the Rome Statute, and it would appear that they made a very deliberate choice to embrace a default jurisdiction when their own national capacity, either technical capacity or political capacity coming out of crisis and so on, made it impossible for impunity to be addressed domestically. So frankly, I think it's more a question of having the right dialogue with many sort of African actors about the value and the role of the ICC, a treaty that every single one of them except Sudan, of all these African ICC initiatives, are treaty-based, not Security Council referral-based. So I don't see there the same kind of difficulty. We would be spending a lot of time, I think, debating these tensions between peace and justice and whether an indictment would be an impediment to peace. It's very difficult in retrospect to speculate as to whether the speed at which the Security Council referred the case of Libya to the ICC, and more importantly, the extraordinary speed at which an indictment was then produced compared to the almost 4 years it took in the case of Darfur after a Security Council referral to produce an indictment, whether this in fact was an impediment to potential negotiations. Very difficult to tell. I think it's pretty fair to say there was not an enormous appetite for negotiations in many quarters. The African Union was pretty well the only champion of a negotiated track. So it's difficult to speculate. I mean, theoretically, it certainly didn't help. I think one might say, in the same way that the negotiations with Joseph Kony, now the teenage idol, the negotiations, the peace negotiations in Uganda with Joseph Kony were certainly not enhanced by the existence of an indictment that could neither be negotiated away by the negotiators, because they didn't have that authority, and that produced a profound conflict of interest in Kony himself, purportedly negotiating a political agenda, although it was pretty obscure to me. I never really saw the LRA as the champion of the Acholi people, but that's another issue. But being himself, in the same way that President Bashir of Sudan is, having a very profound conflict of interest, trying to preserve his own personal interest and that of either his country, his political party, his supporters. Frankly, I see only two ways to go on these peace and security tensions. Either to admit and to make justice subservient to peace, and just to basically surrender it and let political negotiators, mediators, and their political masters negotiate away indictments, trigger them, suspend them, and so on. In my opinion, it would be very sad, because I think it would be the end of a genuine aspiration for the integrity of an international justice process. The other way is to completely separate these tracks, but really completely. In which case, you could say to Bashir or President Bashar, if his time comes, as you could have said to Joseph Kony, this is not a conversation we can have in the same way that in a domestic system, there's nothing politicians can do if you're indicted. If there is a justice track and it is credible, to use my metaphor, people rise when the ICC acts, then there's nothing to negotiate. There's no conversation to be had. There are parallel tracks. Sometimes the tracks will be very far away from each other. At other times, they will be uncomfortably close, but there will be no suggestion that one gets traded away for the other. In my view, that's the way to go, and that certainly would require further distancing from the Security Council as a first step, but not the only one.
Louise, can I ask you something that continues the conversation of a few moments ago, and that is to look at the countries in the Middle East and North Africa now going through transition. Obviously, part of their transition is creating states of law, creating judiciaries, legal societies which were not very legal to begin with. They're at the point right now of just building the institutions, building the buildings. Is it possible, is it fair to say, when you build those institutions and those buildings, make sure they address your concerns about the content of the law, not just the building or the enforcement of it? I don't know if you're following these transitions at all to know if that's the direction people are going in as they advise these countries on how to create their institutions of law. But do we not run the risk in cases like some of these countries of the perfect becoming the enemy of the good?
I don't think so. I really don't think so. I think if we had our eyes on, it's root causes, why are we in this conflict? What is it substantively? What kind of grievances could be accommodated? What kind of interlocutors should no longer be disenfranchised because we don't like the way they've behaved? I think a lot of it is actually eminently doable if we go away. It's like measuring anything else, donors in particular, but anybody is engaged in trying to measure impact. And it's a lot easier. We used to build roads. That was a very good way of measuring how we spend our money and how we've helped this country. And then stadiums and so buildings, it's very tangible. Now we do police training and more police and better equipped, and they have cell phones and they get their human rights training, and it's all measured. We do it because it's the easiest thing to do. It's the most measurable thing to do. But it seems to me that if we engage with equal energy and put as many resources in looking, for instance, at the political accommodation through decentralization, in Somalia, for instance, can we pursue a security agenda in perpetuity or maintain a kind of transitional arrangement that is by any measure not in any way of transforming itself into permanency, when in fact there's minority accommodations, decentralization issues that have to be addressed? I think it's all doable. It's just harder. It's harder, it's less tangible, it's very long-term. The World Bank Development Report in 2011 on development and security made the case loud and clear. If you're talking about even just building credible judiciaries, competent, professional, independent, trustworthy judicial systems, you're talking decades. And you're going to have to be very creative. Exporting the either common law or continental model is a non-starter. And neither, in my view, is kind of old tribal customs, none of which have ever been friendly to women. I think that's pretty fair to say. That's not the answer either. We have to engage in the creation of indigenous institutions that are very contextual. That's one of International Crisis Group mantra. Everything is contextual. There's no fix unless you get that story straight. Its actors, its issues, its opportunities. But all that is, it's harder to design the right initiative. It's harder to measure achievements, and you have to stay the course. You will not build. Elections, in a sense, are easier. They come every 4 or 5 years, and then we deploy a whole array of activities. A lot of it is very mechanical. We're much better at the mechanics than at the politics of elections. And then we think we've built a democracy. Well, electoral democracy does, as I said, nothing for minorities. It does nothing for, and what it does for the most part is reinforces an executive power. It gives the trappings of a legislative power, and there's not even a nickel spent on the judiciary, on free press, on civil society, on all the other absolutely essential components of democratic life.
My name is Marjan Kamara. I'm the ambassador of Liberia to the UN, and I want to thank you for a very stimulating, animated delivery. I tend to agree with Mr. De Laurenti. I think he was the one who started a train of thought. I think that when you're dealing with a post-conflict situation, you're looking at nothingness. In essence, post-conflict Liberia, where everything has been destroyed. The process, first of all, it's a process, rule of law. It becomes a process, and I think you try to do both things at the same time. You try to put the structures there because there's nothing, but you also try to change the laws where you can, and you have to do a lot of training. And some of that training is necessary for what you're talking about. I mean, if the police doesn't understand that he has to respect the rights of the people, what is he going to do? So maybe it appears that the international community, and I have to say that Liberia is doing a lot of what it's doing with a lot of support from the UN, but maybe because structures are there, they are visible, it appears that nothing is being done on the substance of the law. And you have admitted that changing the culture takes forever. So slowly you work on the substance, but I think it's very important that we cannot underestimate or give secondary consideration to the structures and to the training and all of these things that will help you, in fact, to make that culture of respect of rights something, a reality. Yeah, so, and I think the UN is playing a role as a reminder. Yes, what you have said is a reminder. Let us not forget that this is also important. But I think that there is a good effort in my country anyway to make a balance. Thank you.
If I could give you, I don't, obviously I don't disagree, and I don't underestimate the enormous magnitude of the challenge of building. We always say rebuilding, in a lot of cases it's really building from scratch institutions. But I will give you an example where we make the same choice every time because it's the easiest choice. In my view, it's a choice that is an affront to the rule of law. When I was the High Commissioner for Human Rights, every visit that I did in, well, not every, in several developing countries, there was a serious problem of overcrowding in prisons. I also add, it's a very severe problem in a lot of developed countries as well, not receiving exactly the same kind of attention necessarily. So you go to a prison, grossly overcrowded. Donors come in, they're outraged, reasonably so. Conditions are terrible. What do? Ease overcrowding, build more prisons. Then you ask, what is the percentage of the people that are incarcerated in that country awaiting trial? 90, 95%. Thereby being the beneficiaries of the presumption of innocence under international human rights treaties. So you have people presumed innocent, awaiting trials for years and years and years, and what we're going to do to alleviate their condition is house them better. Well, see, to me, this is exactly, it's a lot easier. You get a contractor, preferably from your own country, makes a little money, builds a prison, everybody's happy, and now it's not quite overcrowded. You haven't fixed the rule of law problem. You have fixed some kind of institutional problem, but the answer in a rule of law sense is very difficult to implement in that kind of environment. Because to release people prior to trial, you have to have a supervision system. If somebody has just been arrested for rape, you don't want him back on the street the next day under no supervision. On the other hand, the presumption of innocence requires that he doesn't spend 4 years in jail awaiting trial only to be acquitted because you can't find the victim or the victim has been terrorized. So you need to start looking at how you can have pre-trial release under supervision. So you don't build prisons, you train probation officers. But this is complicated. It's a lot more complicated. And you will have setbacks. You will release one and he will kill somebody. And then you will have an outcry and you'll have to build more prisons again. But we have these false starts all the time, even in developed countries.
As I said at the outset, when ICG first called me about 5 weeks ago, saying, how would you like to put Louise Arbour on stage? I said, tell me when and we'll do it. Now you know why. Seldom do we have speakers here, and we have very good speakers here, that speak with this amount of specificity, candor, and I just wanted to say thank you all for coming, but Louise, particularly thank you for bringing yourself and your wisdom to IPI.